Oh, the Admiralty Extension Act. Yes, a 1948 statute extending Admiralty tort jurisdiction to include all cases in which damage or injury is caused by a vessel on navigable waters, regardless of where the injury or damage occurred. Yeah. Now, specifically, the act extended the jurisdiction of damage and injuries that, is that right? Oh, then bridges and piers or to people on them. Now, a pier makes me think of ports. Yes. Let's say I emailed all the ports that I could find the emails of, and maybe you could go through the ports again. Yes. And then the employees of the ports, that there is a lot of admiralty and maritime jurisdiction in the individual ports. That's right. How many of them like getting sued for misprision of felony and misprision of treason? Because I will sue them. Ouch. Now, I emailed them Port of Port Angeles. That's right. Every time a ship goes into the port right now, when the ship is in the water, yes, the Admiralty and Maritime jurisdiction does come into play. And then there's the ferry dock blackball. Poop. I thought for sure that any employee of the ferry, yes, or the ports themselves that have knowledge of misprision of treason are personally liable. Yes. Now, we have what's known as the admissibility. Oh, the quality, state, or condition of being allowed to enter into evidence in a hearing, trial, or other official proceeding. Mm-mm. Now, admissibility can best be thought of as a concept consisting of two different aspects. Oh, disclosure, yeah, to the trier of fact and express or implied permission to use as evidence. Yes, yes, yes. If we think of admissibility as a question of disclosure or non-disclosure, it is usually easy to say whether or not an item of evidence has been admitted. Now, when we consider the question of permissible use, did my wife use as permissible use the arrest of myself on Guam? Yes. When she motioned the court for a dissolution of marriage. And did you, as a judge, read the arrest report from the police department of Guam after my record had been expunged? Now, I would say that it was inadmissible. Yes, it could not be admitted as evidence after my record was expunged on July 24th, the approximate date of 2012. Now, I'm thinking that all of the evidence for the reasoning of the dissolution of marriage was inadmissible. Pooch. The arrest, the diversion. Did she actually give you a copy of the expungement? Right now. No. Then your divorce decree needs to have a second decree, yeah, called the custody decree. Now, when we consider the question of permissible use, the concept seems much more complex. In the first place, evidence may be admissible for one purpose, but not for another. In the second place, questions of the permissible use of evidence do not arise only at the time of disclosure to the trier of fact. Uh-uh. The court may have to consider admissibility in deciding whether to give the jury a limiting instruction. Ow. Whether or not the opponent's rebuttal evidence is relevant, and whether or not counsel can argue to the jury that the evidence proves a particular point. Now, let's look at the evidence against me every time you arrested me. I was found not guilty in 2012. Yes. Yes. Then you arrested me for a crime that took place on December 31st. But you refused to admit the evidence, the admissibility of the evidence. Now, did you think you were going to get a guilty verdict? No. Mm-mm. Now, this is probably going to be another one of those class action lawsuits and quite possibly a large tort lawsuit. Knowing that you have no evidence against the accused and still obligating them to have mental health evaluations, incarcerating them for 27 days, and then dismissing the case because you said they were mentally diseased or mentally incompetent. Now, admissibility of evidence. Let's look at the traffic citation and the two-count criminal complaint. Because I tell you, I'm going to sue you for racketeering right now. Do you understand, Sheriff? What admissible evidence has there been against me for each and every time that you arrested me? Yes. See, you play the game of the admissibility of the protection order. Yes. The problem is everybody focused on this, whether or not I received actual notice of the hearing. Yes. But they didn't focus on this, the forgery of the ex officio Superior Court clerk. Uh-uh. Because the admitted evidence, Exhibit A and B, Jack, yes, didn't have the signature of the forgery on it. But you admitted it as evidence, and it shouldn't have been admissible, yes, without it being exactly like what was served on me in the Squim Public Library. Now, of course, your answer to every problem is, well, he's crazy. Ooch, he's crazy. He's crazy right now. My answer is, well, you're getting sued for racketeering, because every time you paid for a show, you had to pay for a show. Yes. And that means you did have an unlawful debt to whomever you had to pay. You're getting sued for racketeering. Now, Exhibit A, yes. Without the signature of the forgery, Jack, yeah. It was inadmissible, but you admitted it as evidence, yes. It didn't take into consideration, that the petitioner didn't appear in court. Yes. There were two attempts of service on myself. Yes. You served me in the Squim Public Library. Right. And then you served somebody other than myself. Oh, it's inadmissible as actual evidence. Excuse me. See, I don't see a forgery here. See, Jack, it looks the same. This is the copy that I was going to see that coffee stain right there. Yes. This is what was admitted as evidence, Pooch. But what you don't have, yeah, you don't have a forgery on here, Pooch. Now, it looks like evidence, but it is not evidence for that case. What do you say we sue for racketeering? Pooch. Now, I know, Pooch, you had me arrested for failure to appear. Look at how big that is. Yes. But then you didn't tell me that you changed my height and my weight on my driver's license. No. You didn't tell me that Mike Van Proyn was getting all my mail. No. And then I was supposed to know that I have to appear in court when being homeless, not knowing that the last known address had been changed without my knowledge. And you said there was no